This is a conversation. It isn't simply a presentation, although we have some wonderful guests, as you know, to do that, to stimulate our thinking about this important issue. The issue, of course, is the title of our conference, Religious Freedom and Equality, Emerging Conflicts in North America and Europe. Although there are many ways to articulate this, the issue which we tend to focus on most, we did last night and doubtless we will today, is the quest for equality on the part of homosexual persons and the implications of those claims for the issue of religious liberty. Bishop Tartaglia quoted one of my favorite people on all subjects last night, John Courtney Murray. Murray had a great line that I think is germane to us, and that is, often when we talk about disagreement, what we're really talking about is confusion. Disagreement, said Murray, is an achievement, and it's an achievement that I hope that we will engage in today, if you like, clarity. Stephen Law and I were talking, we may agree on more than we think, and that's wonderful. We will certainly highlight those moments and issues of agreement, but clarity, I think, what are the issues before us? What particularly are the issues that have to do with religious freedom? If we can achieve that level of clarity, even if it is disagreement, then I think we will have done what we set out to do. With that, Roger, over to you.
Good. Well, thank you very much indeed, Sir Tom. I'm reminded by the way we set this up that there were three particular questions that were set. The legal and moral frameworks, what are they that govern tensions between claims for homosexual equality and for religious freedom? How are those tensions illustrated in particular controversies? And what is the proper balance between the new claims of equality before the law and existing claims for freedom of religious groups and individuals on the other? In other words, we just want to look at the current situation, but not just describe it, but think how, in fact, we can deal with it. And as we were reminded by one of the questions last night, in fact, the whole clash between equality and religious freedom may seem particularly important at the moment with issues to do with questions of sexual orientation, but actually it occurs sometimes just as controversially in other areas. Abortion was one mentioned last night, but there are a lot of other areas. There are actually at the moment 4 key cases before the European Court of Human Rights from the United Kingdom. 2 are about questions of homosexuality, but 2 are about symbols, the wearing of crosses. And as always, I think that probably arguments about the wearing of symbols stand for proxy about the place of religion in public life and the ability of people to live by their religion generally. Incidentally, I mean, those cases are about whether people can wear crosses, and I was very interested that just a couple of weeks ago or so, a grave was dug up just outside Cambridge in Trumpington of an Anglo-Saxon, well, she was called princess or high-ranking young female, dating to about 680 AD, and the interesting thing was she was wearing a cross. Now, that was significant both because it shows how deeply rooted, even at that early stage, Christianity was amongst the Anglo-Saxons. Of course, it had been here in these islands before that as well. But also, she was wearing a cross as the symbol of her faith, and people said she is a Christian because she's wearing a cross. Now, English courts at the moment are saying wearing a cross is not a core part of Christian belief. It's nothing to do with Christian belief, it's just jewellery. And that rather, I thought, that instance went against that idea. We heard last night from Bishop Tartaglia how, in fact, freedom of religion can often get truncated, reduced to freedom of worship. I don't know sometimes how far this is just careless talk by politicians or how far it's a deliberate attempt to restrict the way that religious people do behave. I notice that this occurs particularly in the English courts because so often at the moment, and this is one of our problems that we want to deal with today, questions of equality and discrimination always seem to trump questions of rights to manifestation of religion. And yet, of course, discrimination against religion is itself written into
questions of discrimination in human rights charters. It's as much an inappropriate discrimination as on grounds of race or anything else. And yet it seems to be forgotten. It's put on one side. Other forms of discrimination trump it. And the courts tend to say, when faced with this kind of case, they get round that by saying, well, of course you find that you've got freedom of religion because you're free to worship. This was, in fact, said in a case of the civil registrar in Islington, which I'll mention again, Lillian Adele. And she was told, no, you've got freedom of religion. You don't have to worry about whether you can manifest your religion in your job. You're free to worship, and that's freedom of religion. Another gambit of the courts is, and I've mentioned it with wearing a cross, is to say, well, of course, this isn't a core part of Christianity. Wearing a cross isn't part of Christianity. Lillian Adele was told that beliefs about marriage are not core parts of Christianity. Highly contentious theologically, I would have thought, and that illustrates the dangers that courts, particularly in this country, seem to be getting into, whereby they seem to be ruling on theological matters. And I always thought that was something courts would want to run a mile from, certainly in some jurisdictions. Another gambit, which I find at the moment, is particularly if the issue is employment. Of course you've got freedom of religion because you have freedom of contract. So, and this is the European Court's line, you're free to act in accordance with your beliefs because if you don't like your job, you can give it up. So you're free to be unemployed. Again, is that genuine freedom? Now, in all of this, I think there are, and this is one thing we want to talk about today, there are differences between the jurisdictions. And one particular difference I thought was illustrated just in the last few months between the United Kingdom and the United States. As many of you will be aware, there was a very crucial case about religious freedom at the beginning of the year about the so-called ministerial exception in front of the United States Supreme Court, and unanimously it was found that the First Amendment of the Constitution did protect religious institutions and enable them to appoint and discipline their own clergy as they wished. A fairly obvious reading of the First Amendment, I would have thought, actually. And yet, in this country, just a couple of weeks before, just before Christmas, there was another case which didn't receive very much attention. The Court of Appeal in London ruled in completely an opposite way, saying that a Methodist minister is an employee, not as previously thought, an office holder. This followed actually a case as well about the Church of Scotland minister, a case which incidentally allowed state interference in the employment rights of members of the clergy in Scotland. That kind of interference split the Presbyterian Church in the 19th century. A third of them walked out and formed the Free Presbyterian Church. And Lord Rogers, who since died, commented at the time, he was a justice of the Supreme Court, that it went without a murmur in Scotland even. And yet the very same issue had split the church. The state mustn't be running the kirk. And yet now it seems the judges in this country can say, no, churches have to employ people under normal employment law, subject to normal contracts, which can be forced by the state, with all kinds of possible repercussions. So that's very different from the United States. So one of the things I think we're going to talk about today isn't just the general problem which face all countries, but how different jurisdictions are reacting differently to it. So I'm very pleased to welcome our three panelists this morning, each of whom I hope are going to talk for about 20 minutes each. First, we'll start with Stephen Law, who's a philosopher in London, senior lecturer at Heathrop College there. Second, Christoph McCrudden, who is an academic lawyer, but now Queen's University Belfast, formerly here in Oxford. Perhaps very relevantly, he's going to appear, I think, for Lillian Adele in the European Court of Human Rights, in the case I was just mentioning about the civil registrar being, in fact, told that she had to conduct civil partnership ceremonies. And finally, John Finnis. I don't really need, I think, to introduce you to him to most of you. He is, of course, very well known for his writings, not least on natural law. He's been based here in Oxford and also at Notre Dame. So welcome to them all. We've got a very distinguished panel. But first, Stephen, can I ask you just to begin?
Thank you. Cool. Thank you very much for inviting me. I'm pleased to be here. I'm just going to read my opening statement, if that's okay. So it's entitled Shifts in the Moral and Legal Landscape. The UK has seen a revolution in its moral and legal attitudes over the last couple of centuries, particularly with regard to discrimination. One of the earliest beneficiaries of changes to the law to protect minorities from unfair discrimination was the Roman Catholic community. The Catholic Relief Act in 1829 aimed to protect Roman Catholics from such discrimination. Legislation to protect Jews was soon to follow. Today, our freedom to hold and espouse or reject and criticise different religious beliefs is protected by law. Our moral attitudes towards women, black people and gay people have also shifted dramatically, and this too has been reflected in the law. Gone are the days when women could be refused employment or the vote because they are women. Gone are the days when hotel owners could put up signs saying no blacks. Gone too are the days when men having sex with men in private risked imprisonment. Today, most of us subscribe to the principle that the state and the law ought to treat all citizens equally. They should not discriminate between, or it should not discriminate between citizens or groups of citizens, granting privileges to or penalising one group but not another, unless there is some difference that justifies that difference in treatment. Of course, it isn't always wrong for the state or the law to discriminate. We suppose it's right that the state should withhold from children rights and privileges that it extends to adults, and only progressively afford them those rights as they mature. But there is an obvious justification for that. Younger children are not sufficiently mature to exercise those rights and privileges responsibly. It may also be legitimate for the state to make, say, breast cancer screening freely available to all women, but not all men, on the grounds that the risk to men is significantly lower. That would not be unfair discrimination. However, almost all of us accept that such discriminatory practices are proper only where there exists a difference between the two groups that actually justifies treating them differently. So, for example, we suppose it unacceptable for the state to withhold the right to vote from black people or from women. Racial and sexual differences may be relevant when it comes to whether people have a right to certain medical benefits, but it's irrelevant to whether they should have the vote. The British public has largely come round to the view that the state and the law should be neutral in this way. Most of us believe the state and law should treat all citizens equally, irrespective of their sex, race, religion, or sexual orientation, and our legal framework largely reflects this view. What role did religion play in this moral and legal revolution? In fact, as we survey the history of these developments, we find religious and non-religious arguments being used both to defend the old discriminatory status quo and also to justify new anti-discriminatory laws. For example, we find religious ideas and arguments being used to defend slavery, keeping the races separate and withholding the vote from women. We find religious people arguing that God intended the races to be separate and also for women to take a subservient role. Yet we also find religious people in the vanguard of those fighting for equal rights for women, black people, and indeed for gay people. We find religious arguments and justifications being given here too, such as that God made all of us in his image. We also find non-religious arguments given from both sides of the fence. For example, we find non-religious ideas and arguments used to justify withholding the vote from women and black people, such as that women and black people lack the native wit and intelligence required to vote responsibly, and then granting them such rights and freedoms will therefore undermine the social fabric. We've been asked to comment on the moral and legal frameworks that govern tensions between claims for equal treatment of gay people and for religious freedom. The point I am emphasising here is that as we survey the history of equal rights legislation in this country, what we see in each case is not, as is sometimes suggested, a clash between religious worldviews on one side and non-religious worldviews on the other. Rather, we find a wide variety of arguments and justifications, both religious and non-religious, on each side of the debate. This diversity of religious and non-religious arguments and positions on both sides of debates about equal rights continues today. We find non-religious people arguing on non-religious grounds, for example, consequentialist grounds that same-sex marriages should not be permitted, and we also find religious people arguing on religious grounds that they should be permitted. So, the current situation. We have been asked to consider gay rights. What is the current public attitude towards gay people and gay sex? The vast majority of British people see nothing morally wrong with same-sex relationships per se. Indeed, they support legislation giving people who have sex with people of the same sex equal protection under the law. It seems that even among Christians, such liberal attitudes are prevalent. A recent Ipsos Mori poll indicated that among those classifying themselves as Christians, which is just 52% of the population, by the way, those who disapprove of sexual relations between two adults of the same sex, 29%, are greatly outnumbered by those who do not, 46%. The same poll also found that 6 in 10 Christian respondents, 61%, agreed that homosexuals should have the same legal rights in all aspects of their lives as heterosexuals. True, the Catholic Church continues to disapprove of same-sex relationships. The official Catholic position on gay sex is usually justified in terms of natural law, a justification that, as usually developed, also entails the sinfulness of masturbation and contraception. This is, of course, a justification that even many Catholics find unconvincing. A friend and colleague of mine, a Jesuit priest who is very knowledgeable about natural law theory, tells me that he sees nothing morally wrong with same-sex relationships. The law that currently protects gay and bisexual people from discrimination in the workplace, in the provision of goods and services and so on, is unlikely to be repealed in the foreseeable future. Still, there remain religious and non-religious people who believe they are entitled to discriminate against people having gay sex. In particular, some Christians who disapprove of same-sex relationships have argued that they ought to be exempt from equality legislation that applies to others. They maintain that such legislation restricts their own religious freedom to act in accordance with their religious conscience. And it is on such claims of exemption to existing law that recent legal cases and media attention have tended to focus. Recent examples involve a case in which the religious owners of a hotel refused on religious grounds to give a gay couple a shared bedroom, and a case in which prospective foster parents who wanted to be able to teach children in their care their religious view on the wrongness of same-sex relationships claimed their religious freedom would be unjustifiably curtailed were they not permitted to foster for that reason. In both cases, it was claimed that religious rights and freedoms were being trampled and that the rights of gay people were trumping the rights of the religious. Of course, we do rightly allow for some exemptions to the law and to professional duties on the basis of, for example, conscientious objection. We believe that pacifists profoundly committed to non-violence should not be forced to take up arms. We do not require NHS doctors who have a deep moral objection to abortion to perform abortions. They are exempt that duty. Exactly when someone should be exempt on the basis of conscientious objection is, however, a hard question to answer. On the one hand, we can't allow that just any appeal to conscience provides grounds for exemption, for then the law becomes unworkable. I could break any law I liked and claim immunity on the grounds that my conscience required me to break it. On the other hand, we don't want to say that in no case can a claim of conscientious objection constitute good grounds for exemption. So we need to develop criteria that determine when it's right to exempt someone on the basis of conscientious objection and when it is not. What sort of criteria ought we to apply? As I say, that is a hard and complex issue about which we can now discuss, if you like. Many factors should probably be taken into account, including, one, is the objection deeply felt and can the objector give a coherent account of it? And two, if we allow for objection or many such objections, will we infringe the rights of others, and or is allowing the objection likely to have a serious negative impact on the quality of the lives of others? While many factors need to be taken into account when weighing up claims of conscientious objection, I am not persuaded that having a specifically religious objection should carry any additional weight. Yes, I believe a Roman Catholic doctor who has a deep religious objection to abortion ought not to be required to perform an abortion. But that is because I believe no doctor who has a very deeply held moral conviction that abortion is wrong should be required to perform one. Are we to say that a Roman Catholic doctor who morally objects to abortion should be exempt such duties, but not a doctor with an equally firm and considered objection to abortion who happens not to be religious? If these two doctors have an equal claim to be exempt, then it's not the former doctor's religiosity that's doing the justificatory work. On the other hand, if we exempt the Catholic doctor but not an atheist doctor, then what justifies us in treating them differently? Why should the conscientious objections of the religious carry more weight than those of the rest of us? Personally, I cannot see, at least not at this point, any justification for giving the religious conscience greater weight. If we are going to accept that religious hoteliers with deep-seated religious objections to same-sex relationships thereby earn the right to refuse gay couples a room, then we will have to allow that, ceteris paribus, other things being equal, religious hoteliers with deep-seated religious objections to the mixing of the races thereby earn the right to refuse mixed-race couples a room. Do we really want to accept that? I cannot see that the addition of a religious dimension to the conscientious objection of hoteliers who object to making rooms available to gay couples or mixed-race couples requires us to take their claim to be exempt from anti-discrimination laws any more seriously than if they objected on non-religious grounds. A hotelier who refuses a mixed-race couple is a bigot. I am using the B word there. Talk about that later if you like. They will rightly fall foul of the law. It seems to me that if the hotelier should turn out to be not just a bigot but a religious bigot, a member of the Dutch Reformed Church in South Africa, for example, whose views on race are underpinned by theology, that would not lend any further credence to the thought that the law should not apply to them. There is clearly a perception among some Christians that the laws that prohibit discrimination against gay couples are anti-religious. Let me finish with an illustration. In the court case brought by the prospective foster parents wanting to be able to tell children in their care that homosexual relationships were morally wrong, their counsel, Mr. Diamond, opened his argument by saying, "This case raises profound issues on the question of religious freedom and whether Christians or Jews and Muslims can partake in the grant of benefits by the state or whether they have a second-class status." Diamond identified the issue before the court as being whether a Christian couple are fit and proper persons to foster and by implication to adopt by reason of their faith, and whether Christian and Jewish and Muslim views on sexual ethics are worthy of respect in a democratic society. Diamond submitted his clients were in effect fighting, quote, a blanket denial on all prospective Christian foster parents in the United Kingdom, end of quote. Indeed, quote, a blanket ban against all persons of faith, end of quote, and an, quote, irrefutable presumption that no Christian or faith adherent can provide a suitable home to a child in need of a temporary placement, end of quote. The judges, Lord Justice Mumby and Justice Beetson, declared, and I quote, "It is hard to know where to start with this travesty of reality," end of quote. They continued, quote, "All we can do is to state, with all the power at our command, that the views Mr. Diamond seeks to impute to others have no part in the thinking of either the defendant or the court. No one is asserting that Christians, or for that matter Jews or Muslims, are not fit and proper persons to foster or adopt. No one is contending for a blanket ban. No one is seeking to delegitimise Christianity or any other faith or belief. No one is seeking to give Christians, Jews or Muslims, or indeed peoples of any faith, a second-class status. On the contrary, it is fundamental to our law, to our polity and to our way of life that everyone is equal before the law and equal as a human being endowed with reason and entitled to dignity and respect. End of quote. Despite this, Christian Legal Center spokesperson Andrea Minichiello Williams claimed afterwards, on the basis of the judge's ruling, that, quote, Britain is now leading Europe in intolerance to religious belief, end of quote, and the CLC, Christian Legal Center, claimed that, quote, the High Court has suggested that Christians with traditional views on sexual ethics are unsuitable as foster carers and that homosexual rights trump freedom of conscience in the UK. So clearly they were very angry. The Christian Simon Barrow from the Christian think tank Ecclesia commented on this legal case, quote, it is wrong to call this judgment a landmark ruling since it does not lay down any new principle but upholds and affirms the law. However, it does confirm what we at Ecclesia have been arguing for many years, which is that the era of Christendom when Christian institutions and beliefs might be given special privilege, regard and exemption denied to others is now over. For many, including Christians who wish to recover the levelling core of the gospel message, that is good news, not a threat. The Christian Jonathan Bartley, also from Ecclesia, has said about this and similar legal cases, people should be aware that behind many such cases there are groups whose interests are served by stirring up feelings of discrimination and marginalisation amongst Christians. What can appear to be a case of discrimination at first glance is often nothing of the sort. It is often more about Christians attempting to gain special privileges and exemptions. This last considered Christian opinion seems to me to be exactly right.
Thank you very much. Well, can we go straight on to our next speaker? So,
thank you. Can you hear me at the back okay, yes? Yeah. Thank you very much for inviting me. It's a privilege to be here and to have heard the Bishop last night. Thank you for that. You kindly mentioned that I was involved in the Liddell case. Can I say right at the start that I'm not going to talk about the Liddell case for obvious reasons.
but it gives you good credentials for being here.
Well, I'm not sure what my credentials are for being here, but you'll perhaps discover the mistake when I finished. What I want to do is not read out my paper, which will be available to you if you want, but rather to speak about some of the prior questions that the paper raises and perhaps assumes. And maybe in doing that to respond to some of the questions that you raised last night, entirely legitimate questions. And I'm taking it perhaps really quite importantly that everyone that's involved in the debate is acting in good faith. So I'm not going to be looking for political agendas or hidden conspiracies, right? I'm going to be assuming that everyone is acting in good faith in this context. So you mentioned really two, I think, fundamental questions last night. One was why homosexuality and why now? So given the potential controversies that might have been raised over abortion or whatever, why does freedom of religion now seem to focus particularly at the moment in both the United States and in England in Britain on the homosexual issues. And then the second question broadly was what's to be done about it in terms of freedom of religion. So let me try and talk a little bit about the first question about why homosexuality and why now. And I suppose the first point I want to begin with is that I think it's a mistake, both in terms of history and in terms of strategy, to assume that it is just about homosexuality. That is, that the current questions about homosexuality, I think, have to be put into a broader perspective, not only in terms of equality issues, but of human rights issues generally. In other words, what I'm suggesting, I think, is that the tensions, which there clearly are, between some religious beliefs and some issues arising in equality and in gay rights, are to do with larger tensions between the current debates in human rights generally and debates within religious communities. And that's where I want to frame it. So what's interesting, I think, is how things have changed. So very broadly and extraordinarily simplistically, we can say that, and I know each of these points are going to be contestable, highly contestable, that, and I'm now speaking of the Catholic Church, that up to Pacem in Terris, there was an ambivalence, let's put it that way, about human rights developments, largely because they were seen to be growing out of Enlightenment thought and liberalism of the 19th century kind that was seen to be antagonistic to some church approaches. And there were hiccups and attempted reconciliations along the way, but the major reconciliation, at least as I read it, is in Pacem in Terris and in the Second Vatican Council, where human rights are, I think, embraced fairly fully. So why did that happen is one question. And I think one of the reasons why it happened, and the history of this I think is actually yet to be written, a very interesting history it is. Part of the history, I think, has to do with the compatibility between the drafting of the Universal Declaration of Human Rights and current approaches that were articulated as what we'll call personalism in France, and particularly in France, in the 1920s, 1930s, which were then adopted by Maritain and translated into, Jacques Maritain, and then translated into public discourse, and in part fed into the Universal Declaration of Human Rights. And personalist kinds of language is riven throughout the Universal Declaration. In particular, notions of human dignity, and in particular, the adoption of the idea of the person rather than the individual as the focus of attention. And the language here is important. And person is there in order to, as Maritain, I think, saw it, to emphasize that the role of human rights, as indeed was the role of personalism, is to reject individualism, radical individualism, but equally to reject depersonalization arising from totalitarian philosophies, but both of Nazism and of racism and of communism. So in currently fashionable terms, it was genuinely a third way between radical individualism, including market individualism, and totalitarianism. Okay. So that seemed to be the high point, as it were, of coincidence between the approach that the Church, as at least articulated by Maritain, and I have to say to some extent subsequently adopted by Pope John Paul in terms of his adoption, personalism, coincided with the development of human rights. So there's a moment where they coincide together. And that's essentially between 1945 and 1968, let's say, with the Vatican Council, which again adopts human rights very centrally in terms of its understanding of the proper role of the state and of the proper role of the church. So the question is, what happened, right? So why are we now in a situation where there seems to be a deep antagonism, potentially, between aspects of what we'll call a human rights agenda and what we'll call, at least Catholic, approaches to the individual and to the person, culminating in the most recent debates about homosexuality, but by no means restricted to that. And that story, I think, is also an extremely interesting one and has yet actually to be written, that history. So what I'm going to suggest very tentatively, and I mean that tentatively, so I'm very much open to contradiction and correction in this, is that two things happened, two major things happened. One in the human rights agenda, and two in terms of the debates within at least the Catholic Church. In terms of the human rights agenda, three major events happened, and I'll concentrate now on the equality questions, because that's partly what we're dealing with today. First, gender equality happened. And gender equality, as you point out, is absolutely fundamental to this debate. It's interesting that, as it were, the legal and particularly the human rights approach to gender equality happens after, largely, 1968. Now, obviously, you know, in terms of those who know the history, it would be foolish to say it started in 68. Clearly didn't, but it certainly comes to a considerable degree of importance after 1968. So that's one thing that happened. Second thing that happened was racial equality. Effectively starting with South Africa and apartheid, but then United States and throughout the world. Now, those two events, right, the concentration of on gender equality and race equality, are, I think, absolutely central to the debate today in several respects. One respect in which they're central is that increasingly the equality agenda on race and gender challenged essentialist thought, challenged the notion that categories of race or gender were firm and settled. It's clear, and I think probably universally agreed, that is the appropriate approach to take with regard to race. That is, that we recognize that race is a constructed category, not an essential category. So there's a degree of consensus on that. With regard to gender, it's a lot more debated. In terms of human rights law, it has increasingly taken an approach that essentially undermines essentialist approaches to gender, as with race, and it adopts essentially a constructivist approach with regard to the understanding of what we mean by gender, sex, and these other categories. That's one development with regard to the human rights equality agenda. The other development that's important that arises out of this is, in particular, in the European context, less so in some respects in the American, but particularly in the European, an idea that we should be concerned with what are often called expressivist harms, expressive harms. Now, by that I mean the notion that harms are not only material harms, this person didn't get a job, but also some approaches to gender inequality and race inequality attack the essence of an individual's identity in a way which is not just offensive, but deeply wounding. Now, let's call that an expressivist approach. Now, also combined with the rejection of essentialism, there is a strong adoption of an expressivist approach. Hence, notions of race hate. Right? So in the European context, very strong approaches, which I know depart from the American constitutional tradition, but of preventing racial hatred speech. And that's been applied increasingly not only in the context of race, but also in the context in Germany of the denial of the Holocaust, and so on. Those are kinds of attempts at dealing with this kind of expressivist harm. Okay, so major developments in terms of the human rights agenda. The third element of the human rights agenda that happens is the increasing expansion of the grounds of protection. So it goes from gender, race, through to religion, as you rightly pointed out, sexual orientation, age, disability, whatever. So in other words, what I'm suggesting is that the protection from discrimination with regard to homosexuality is part of a very long strand of decision making, which has particular attributes. Okay, turning then from that to the discussion within the Catholic side, I think there's also been change. We sometimes want to minimize changes that occur, but they're identifiable. And one of the changes, I think, has been the resurgence of natural law, not least due to John Finnis. And there are particular aspects, and I'm treading here on dangerous territory given that John's sitting beside me. Right? Some aspects of the natural law discussions clearly have affected the debate in profoundly important ways. In particular, I'll mention just two. One is that the emphasis on complementarity, I think, is an essential part of this debate. And in particular, some aspects of the complementarity argument that essentially emphasize the biological aspects or physical aspects of complementarity. And I think that poses, it is seen as posing, let me be careful here, it's seen as posing particular tensions with the notion of constructed identities that we've seen already appears as an important element in the legal and human rights agenda on equality. So the more that complementarity in natural law is interpreted as essentialist, in other words, the more it comes in tension with aspects of the human rights agenda. So that's one element. The second element, I think, that happens in new natural law, and again, I'm very much looking forward to being contradicted on this, is that the focus of attention shifts from France in the 1930s and 1940s, where essentially the debate is occurring, to the United States. And I think it would be a mistake to underestimate the importance of that shift of gravity, as it were, from France to the United States. So it shifts from Europe to the United States. And to some extent, at least, gets caught up in American political debates. There is, I teach every year in the States. I know and love the States. I was a graduate student in the States. I was very, very close ties with it. Wonderful, but it's different. Right? It's really different. The longer you spend there, the more different you identify it as being. And one of the ways in which it's different is that there is, I think, and this isn't a criticism, it's simply an observation, a very close connection between some of the religious debates and the political debates. So the close involvement of some of the religious issues in Obamacare, for example, is an illustration of this. Right? There is a political agenda as well as a religious agenda. I'm not trying to criticize any side. There is a combination there. That's just different in Europe. And the importation of some of that language, I think, is an unfortunate development. The last thing that we need in Europe is an Americanization of the debate between the state and religion. That is not what we need. I come from somewhere in Northern Ireland, right, where, as in Scotland in the past, where we know the dangers of the politicization of religious debates. So, two things then happening. Changes on the human rights side, developments at least in terms of the religious, at least Catholic side. Now, coming back to Stephen's point. Stephen's point's important, I think, in this respect, that within both the human rights debate and the religious debate, there is no orthodoxy that is a settled orthodoxy, in my view. In other words, there is as much debate within the Catholic Church on some of these issues as there is within the human rights area on quite a lot of those issues as well. Let me give you an example. Right? So, for example, the emphasis in equality on expressivism gives rise to severe tensions with some notions of tolerance, as you were pointing out last night. So the more you restrict speech, the more intolerant the human rights agenda can look. So in other words, what I'm suggesting is there are flexibilities in this debate that need to be understood and identified rather than an assumption that there is a clear orthodoxy. Human rights groups that I speak to assume there is an orthodoxy and unchangeability in terms of church doctrine. Church groups that I talk to assume that there is a permanence and an unchallengeability and a lack of flexibility in the human rights agenda. Neither of those seem to be correct. They are both in dialogue, internally and externally. Okay, so what to do then is the question. So the answer to I think to your first question, so why homosexuality as now the issue? It's because it's equality. It's because it's an equality issue. And because equality, it's an equality issue. And it's identified by those who are pursuing that, I think in entirely good faith, as an equality issue. And equality is, like it or not, part of the current zeitgeist. That's not going to go away anytime soon, nor, I think, should it go away anytime soon. So the question then is what to do about it. Right? So we have debates within, as it were, both camps. It's always unfortunate to talk about camps, but you know what I mean. And there is an apparently irresolvable tension between those. Neither side, if you want to call it a side, is going to give way on this. Not least because both sides, and this is also a development in human rights thinking, claim to be speaking the truth. They don't frame it in those terms, but they do claim to be speaking the truth. The old phrase about speaking truth to power is a well-known aphorism within the human rights community. And certainly they see themselves, we see ourselves, as having important insights into right conduct. So what to do? The more each side speaks in terms of the truth, the more difficult it is, therefore, to resolve the question because there is a potential for irresolvable conflict. And now I come to my paper in the last 2 minutes. And I come to the paper because essentially this is going to be an area, I think, of continuing discussion throughout the day. And the suggestion here is, and it's picking up quite a lot of the American discussions, and particularly Professor Wilson's work, is that we need to think seriously about what is sometimes called reasonable accommodation. But I think it's probably, it needs a lot of nuance in terms of what we mean by reasonable accommodation, because one of the other difficulties in speaking to, I'll call it a mixed audience, mixed in many ways, but mixed certainly in terms of lawyers and non-lawyers, and mixed certainly in terms of Europeans and non-Europeans. Reasonable accommodation means different things to different people. What I'm going to suggest in my last minute is that the Germans got it probably about right. And I'll leave you on this point. So what happens is this. So, and this is my only comment on Liddell. The way that, and this is because it's public, the way in which Liddell is being organized is that it is a claim of a breach of Article 14. It is not a claim with regard to freedom of religion. That is, to be a bit more explanatory about this, it is a claim that my client, Ms. Liddell, is being discriminated against on religious grounds. That is a different claim than a claim to freedom of religion. It is not being run as a freedom of religion claim. Now that's important, and it's important because it reorients the discussion in a way that I think the lawyers will appreciate, and perhaps the non-lawyers will not, and we need to talk about it a bit more. Here's the point. The point is that in formulating it as an equality claim, and I'd suggest that this is an appropriate strategy more generally, the debate then becomes a debate within equality rather than a debate between equality and freedom of religion. If you formulate it as a debate between equality and freedom of religion, equality will trump. That is not a moral question that I'm stating, not a moral proposition I'm stating, it's not even a political statement I'm making. I'm saying legally you will lose. So, if you want to be a martyr, you will run it as a freedom of religion claim. If you want to win, you will reformulate it. Now, that is not, I'm not making this as a tactical point. I'm saying it's a different argument. Now, where does the question of reasonable accommodation come in? It comes in this way. Given that it is a conflict within equality, right, between equality on grounds of sexual orientation and equality on grounds of religion, then you have a problem within the notion of equality itself. Now, what the German Constitutional Court in its wisdom says, I think absolutely rightly, is that in that context where there is a conflict within the equality dimension itself, then they have a term, and the term is practical concordancy. And practical concordancy essentially means that each element of the right should be given as large a space as possible in which to operate. Now, that involves an important compromise. Right? It involves a compromise insofar as it requires both sides to say that the other's basic argument is one which is, if not acceptable, legitimate. So no one gets to trump anybody else's position. That is a genuinely pluralistic argument, but it doesn't give anybody success totally. What it means is essentially a compromise which is a workable compromise which allows people to live in a public space together even if they fundamentally disagree. And that seems to me entirely the appropriate approach to take. If you want to call it reasonable accommodation, there is a potential problem because you then get all the baggage of American reasonable accommodation law, which basically sucks. Technical term. But it's a useful handle in order to get the debate going. It's not what I would suggest we adopt in Europe, but the term is nevertheless a useful one because it conjures up the notion that essentially you live and let live, to use your term. That's the argument I'm putting in the paper. It's somewhat more technically put in the paper. I thought I should talk about it in more general terms. Thank you.
Thank you very much. We're going on to John Finnis then. Thank you.
Thank you. Well, I will read my paper, which you find in the book. I won't look into the extensive footnotes which you have before you. The version that's bound up in the book is the one that I originally sent, but not the one that I sent a bit later, which has an additional footnote at the end about the case of the bulls, which was alluded to by Stephen Law. A couple of vignettes from, and I should say at the end I will add 5 minutes or so beyond what's in the book. A couple of vignettes from current litigation in or involving England will take us to the heart of the matter, although this is now slightly stale news given the Chairman's opening remarks. In July 2011, the Equality and Human Rights Commission, a body established under the Equality Act, which in its self-description enforces equality legislation on age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation, and encourages compliance with the Human Rights Act, unquote. The Commission announced that it was seeking to intervene in 4 cases which, as we have heard, proceeded from the English appellate courts to the European Court of Human Rights. In all 4 cases, it would argue, the Commission would argue, it announced, first, that the English courts were taking too narrow a view of the kinds of restrictions which engage the right to freedom of religion. By holding, the courts were holding, for example, that the right is not engaged at all if the relevant individual's desired manifestation of belief is one not required by that person's religion, or is one that others of that faith who are employed in the same business do not insist on being allowed to manifest, or is one that the individual could manifest without restriction by moving to another more accommodating place of employment or school or other relevant environment. And secondly, it would argue that where the right is engaged, that where the right is engaged and the question of the restriction's justification is therefore the issue, the courts should, but do not, adopt a principle that where practicable, there should be reasonable accommodation of manifestations of religious belief, wherever that can be managed with minimal disruption of the relevant operation, business, school, public service, etc. And no doubt if the Commission had pursued that purpose, it would have framed its argument both in terms of the phrase reasonable accommodation and in terms of the doctrine of practical concordancy or other more or less equivalent legal dogmatic terms. Now the 4 cases were first of all Eveda's case and secondly Chaplin's, which both involved a claim to be allowed to wear a small cross or crucifix on a necklace made visible by British Airways' change from high-necked to V-necked female uniform, a claim refused at the relevant time by British Airways and the employment tribunals and appeal courts, though later accepted without difficulty by British Airways under the pressure of newspaper campaigns. And thirdly, Ladil, and fourthly, McFarlane, which both involved requirements imposed by employers pursuant to policies of prohibiting discrimination against same-sex couples. Lillian Ladil was a registrar employed in the Council's Registry of Marriages who was unwilling on Christian religious grounds to conduct civil partnership ceremonies, which are always with a view to or in recognition of same-sex sex acts, and it was not denied that it would have been easy for the Council to use other registrars in its employment to conduct any and all such ceremonies instead of Ms. Ladil, and to do so without imposing disparate burdens on those other registrars or unfairly lightening her load. But the courts held in the Equality Commission's accurate summary that the legitimacy of the Council's aim in imposing a policy of equality for practicing homosexuals automatically means that its requirement that she conduct these ceremonies was proportionate. Again, another dogmatic legal term, roughly meaning reasonable. No question of accommodation on this view of the courts could arise. Gary McFarlane was employed as a relationship counsellor for a charity and on Christian religious grounds was unwilling to provide psychosexual therapy advice to same-sex couples when that became required. Again, there was no suggestion that the charity could not have reached a reasonable accommodation with him by using others of its counsellors for such couples. But the very senior and scholarly judge who disposed of the final appeal application concluded, "There is no more room here than there was in Le Deal for any balancing exercise in the name of proportionality. To give effect to the applicant's position would necessarily undermine the charity's proper and legitimate anti-discrimination policy." But within 6 weeks, the Equality and Human Rights Commission's position favouring reasonable accommodation or practical concordancy between religious beliefs and gay rights policies had been publicly reversed. The Commission announced that its submissions to the European Court of Human Rights in the Le Deal and McFarlane cases would now be in support of the English court's decisions. When its submissions were published in September 2011, they were found to argue, rightly and effectively in relation to all 4 cases, that the English courts have been far too restrictive about when the right to religious freedom is engaged. But there was no plea for a doctrine of reasonable accommodation. While they did not explicitly reject, they did not quite endorse the position of the courts that, as the Commission summarised it, the refusal to accommodate discriminatory religious beliefs will always be proportionate. The Commission instead said, "In the Commission's view, it will generally be proportionate to refuse to make an accommodation in cases where a public sector employee seeks to be exempted from providing a public service on discriminatory grounds. Very strong arguments and evidence are required to prove the employer has acted disproportionately in cases such as these. State services must be provided on an impartial basis, and employees cannot expect their public functions to be shaped to accommodate their personal religious beliefs," unquote. And whether these remarks apply to McFarlane is left in shadow. The real ground of the Commission's position and of its reversal of position is indicated in the immediately preceding paragraph of the submission to the court. I quote, "In the words of Judge Tulkins in Sahin against Turkey in 2007 in the European Court of Human Rights, it is necessary to seek to harmonise the principles of secularism, equality and liberty, not to weigh one against the other," unquote. Nonetheless, this court, the European Court of Human Rights, has recognised that interfering with some rights will require particularly strong justification. The right to equal treatment on the grounds of sexual orientation is one such right, unquote. Thus, gay equality rights continued on their prioritised way, simply trumping religious and associational freedom. To conclude this vignette, I need only add that in March 2012 it was reported in the newspapers that the United Kingdom government's submissions in the Ouida and Chaplin cases would oppose the Commission's position on the first point and would maintain that, I quote, "the applicants, the employees' wearing of a visible cross or crucifix was not a manifestation of their religion or belief within the meaning of Article 9 of the European Convention about the right to religious liberty, and the restriction on the applicant's wearing of a visible cross or crucifix was not an interference within their rights protected by Article 9, and thus did not need to be justified as a reasonable or proportionate restriction of those rights." The government's argument appears to be that wearing such symbols is not, quote, "a generally required form of practicing the Christian faith, and is not regarded, including by the applicants, as a requirement of the faith." To me, as to the Commission, the Equality Commission, it seems that such considerations manifestly belong to the Article 9.2 issue of unjustified limitations, or justified or unjustified limitations, not to the Article 9.1 issue of whether the right to manifest one's religious belief is engaged. In relation to Article 9.1, the appropriate issue is simply whether the complainant's religious belief is genuine, not tactical or factitious, and is being manifested in the practice sought to be restricted. But the position of the English courts is no accident. They have been following a course of European Court of Human Rights jurisprudence, strongly minimising the Article 9 right, in part by minimising quite implausibly the scope of Article 9.1. Hence, in part, the position that Professor McCrudden articulated for us just a moment ago: equality trumps religious liberty, not of course morally or realistically or humanly, but in law, according to the dogmatic structure of contemporary European jurisprudence and bien-pensant opinion. The foregoing vignette happens to concern individuals confronting employers or analogous authorities. But the impact of equality law on religious associations and associations with a religious ethos has been even more serious, far-reaching and one-sided. The negative impact of the United Kingdom equality law on freedom of religion and conscience here overlaps with its negative impact on other established constitutional rights, such as freedom of association and freedom of parents to educate their children towards good forms of life, a negative impact which in each case involves also a very substantial shrinking or invasion of private life by coercive law, not to mention freedom of speech. The requirement that parents who wish to band together to employ teachers for their children must be fully willing and ready to employ as teachers qualified applicants who live openly unchaste lives according to the conception of chastity accepted by those parents and desired for their children's education, is plainly an interference with their legitimate interest in associational freedom. And it is quite disproportionate, given that the only kind of unchastity protected by the equality law is one indulged in by persons sufficiently few to find equally desirable employment in schools uninterested in promoting chastity or that conception of chastity. In some jurisdictions, anti-discrimination law still exempts from its provisions about homosexuality the employment practices of private schools and the services provided by adoption agencies run by faith-based organisations. But even in those places, and I mentioned New South Wales, people who agitate for repeal of this exemption wrongly call it, as the United Kingdom government called it, an arbitrary license to discriminate. The disproportionality or needlessness of the refusal to accommodate associational and religious liberties in the law against sexual orientation discrimination in the employment practices of schools was even more vividly manifested by the law prohibiting adoption agencies from continuing to give effect to their judgment, the judgment shared until the other day by everyone and quite unrefuted, but supported by the religious faith of the agencies and their sponsors, that both the unchastity and the lack of complementarity involved in adoption by same-sex partners should count as at least a negative factor, if not a disqualification, in decisions about adoption. The law is clear that to count it even as a negative factor at all is unlawful. This coercion, resulting in some cases in the agency's withdrawal from providing adoption services at all, was imposed by the British enactments, even though would-be same-sex adopters had available other suitable and vastly more numerous adoption agencies willing to cater for them. This legislative imposition is similar to the judicially approved administrative impositions in the vignette cases of conscientious objection by employees or would-be foster parents who are unwilling to cooperate with what they consider unchastity and injustice to children, and whose position could easily have been accommodated without material detriment to the public policies to which they, as I think, reasonably objected. In all these cases, the courts have proceeded straight from affirming the legitimacy of an anti-discriminatory aim and the efficacy of the anti-discrimination policies means, to concluding that the policy was justified and the conduct it prohibited was discrimination in the genuine sense, that is, unjustified discrimination or differentiation. These courts neglected their duty to consider whether the means, the policy, was not only effective but proportionate in the legal sense, that is, did not affect people's legitimate interest in other recognised rights more than was needed by the legitimate aim. The current discourse and consequent legal regime about discrimination, harassment and victimisation effectively suppresses, or at best misframes and distorts, rational discourse and sensible judgment about the interests of children and the conditions of demographic and cultural sustainability, in which religions too take a keen interest. Thus in England the law has in 2 decades been transformed in ways affecting its most fundamental social relationships, the familial, a central concern of its long fundamental religion. In 1988, to maintain the historic judgments of its people, Parliament ruled that public authorities should not, quote, promote the teaching of the acceptability of homosexuality as a pretended family relationship, unquote. This was repealed in 2000, and by 2007, statutory and judicial rulings had made it unlawful for any public person or body, and for any private person or body employing anyone or offering any service to the public, to use at all the philosophically sound and religiously endorsed criteria of chastity and marital and familial integrity in the course of assessing how employing openly unchaste homosexuals or how providing a service promoting the acceptability of homosexual sex relationships might affect the long-term well-being of children and their families and the parental and religious rights of those children's parents. Innumerable bystanders and participants in this revolution assumed that what was at stake was no more than the protection of a small minority with a certain inborn predisposition, perhaps, against denials of employment or service unrelated to their competence, their conduct, or their proselytizing for an unchaste way of life. And that assumption was mistaken. And as for religious, associational and conscientious freedom, the guarantee offered by the politicians to religious associations in enacting the Human Rights Act 1998 proved to be quite worthless. Section 13 of the Act reads, under the, with the side note or heading, freedom of thought, conscience and religion, if a court's determination of any question arising under this Act might affect the exercise by a religious organisation itself or its members collectively of the Convention right to freedom of thought, conscience and religion, the court must have particular regard to the importance of that right. The courts soon declared that whilst there is a need to have specific regard to the rights protected by Article 9, Section 13 of the 1998 Act, does not give greater weight to those rights than they would otherwise enjoy under the Convention. The provision has had no effect in any of the cases concerning associational religious liberty and the equality laws. Well, since writing this, I have learned that other participants' papers have entered into the merits of the issues. That is, whether religious freedom or belief deserves any protection at all, or special protection at all in law, and whether there are any rational grounds to object to the laws outlawing discrimination against people who publicly announce their practice of same-sex sex acts, where the unfavourable treatment of them in employment or provision of services is motivated by concern to protect children from influential rationalisation of unchastity, or to give witness to truths about chastity and unchastity and their importance for the common good. I have written a fair bit on both these issues. On the first, the protection of religious liberty as such, you will find an essay at the beginning of Volume 5 of my collected essays. And on the second, you'll find 3 essays near the end of Volume 3. The ground for treating religious conscience as specially important is that it is really of great importance that people should seek and form a responsible judgment about an issue of unsurpassed importance, the truth about the origin, significance, and destiny of the entire universe, and of human beings as the only beings within our experience who are capable of engaging with reality in this uniquely profound way. To treat a genuine religious objection to, say, to take the example Stephen Lord took, to mixing of races, as of no more weight than a quasi-aesthetic prejudice against people of different colour, is misguided, even if and when we disqualify the objection, the religious objection, in the field of provision of services, advertised sales, etc., on the ground that it is religiously mistaken and contrary to an important public policy. Of course, the special weightiness of religious beliefs has a further consequence, which is of great public importance, but is not really on the table here amongst us today. If a significant number of citizens hold religious beliefs incompatible with our public order, including the right to religious liberty, we have a special problem, which may require extraordinary solutions. To treat the objections to same-sex marriage or pseudogamy as discredited because the sky has not fallen after 9 years or a decade seems to me about as misguided an approach to human and social reality as could be imagined. The sky would not fall if and when polygamy or marriage with domestic pets is introduced, any more than it fell when the Nazis entered Paris and a wonderfully erotic 4 years began, recounted in 2 volumes by a recent French writer. Telling married couples with the voice of the law and state backed up by the intensive state propaganda that we see being imposed, say, on the Catholic school system in Ontario, that their marital acts are of the same moral quality as masturbation or sodomy, and that their lifelong commitment to complementary parenting is of no more value and importance to children than that of 2 men or 2 women purchasing a conception, a pregnancy, and a child, whom they will in every case thereby deprive of the care of its mother or father or both. Telling married couples that is really, even if countless married people do not now realize it, a trashing of the natural and fundamental unit of society, as the Universal Declaration of Rights puts it. And beyond that, it is a demeaning of married couples and an insult to them of unparalleled depth and severity. Check back in 50 years to see how it panned out, both in accelerating the disintegration and collapse of societies already undergoing visibly rapid, unprecedented cultural and demographic decline, and in miseries for very many of the children who do get born thus. Well, those remarks are very summary for the relevant philosophical arguments pivoting on the meaningfulness of marital sex acts. See the 3 essays I mentioned, which build on the insights of the best philosophers of all time, Plato, Aristotle, and Aquinas, but are offered on the merits of the arguments and without appeal to authority, philosophical or religious. The sophisms that have been deployed in and by the United States courts, as we will hear later today, essentially take the form of converting the moral critique of kinds of acts which contempt almost everybody, as anyone who has been to a single-sex boarding school or in the Navy is well aware, and against which children therefore need to be warned, converting that into a mere prejudice or animus against persons. That's the essence of the sophism. The results include, of course, blatant discrimination in favour of same-sex couples as compared to ordinary adulterers or fornicators, who have no legal grounds for complaint when they are excluded from a hotel such as the Bulls out of religious and moral concern to witness to the importance of marriage. A final word. What we're considering today are essentially legislative questions. That being so, the issue is generally miscast if it is presented in terms of exemptions to the law. The question is, what shape should the law take, given the rights and interests people have in equality, religious liberty, freedom of speech and association, education of their children, and so forth? The Equality Act 2010 has 218 sections plus 28 schedules, totaling in all several thousand distinct propositions needed to state what a hostile rhetoric might call exemptions, but more sensible assessment would call, as the Act does, exceptions to general propositions which, if unqualified by these exceptions, would be manifestly unjust and intolerable and contrary to many accepted public policies. The true question is not about exemptions in favour of religious and similar interests, but the extent to which they should have been, those interests should have been accommodated amongst the thousands of other allowances, qualifications, and reasonable differentiations. Thank you.
Well, thank you very much. Now, just before we open it to general discussion, you'll notice that this session is titled United Kingdom and Ireland, and we've just been talking about the United Kingdom, but there are people here from Ireland. And so could I ask David Quinn from Dublin just to talk a little bit about the position in the Republic of Ireland as of now, which is, of course, itself raising big issues about religious freedom.
Thank you.
Thank you.
I'll be very brief and almost entirely descriptive and just give a few examples of the cases that have been occurring in Ireland recently. Only one will have to do with the issue of homosexuality, the others will have to do with other issues. And I'll start off with the issue to do with homosexuality. We too have introduced civil partnerships about 2 years ago, 18 months ago. One of the laws in respect of that is if a civil registrar won't officiate at one of these ceremonies, that civil registrar could go to prison for up to 6 months. I believe that's even more drastic than the case in Britain. That's the only one I'll mention of the homosexuality issue. Pharmacies. Once upon a time, pharmacies in Ireland and pharmacists could not sell the morning after pill at all on the grounds that it's an abortifacient. Then the law changed so that pharmacists could sell the morning after pill if they so wished. Now, under the Code of Conduct for Pharmacists in Ireland, every pharmacist in Ireland must sell the morning after pill. So we've gone from can sell it to must sell it, which is a rather profound change. We had a case involving a doctor who runs a fertility treatment practice. He uses something called naprotechnology. It's run along Catholic grounds. He will treat only married couples. A cohabiting heterosexual couple came to him wishing to use the service, and he said, look, I run this in Catholic grounds. I treat only married couples. He was taken before the Fitness and Practice Committee of the Medical Council, and he was acquitted only on a technicality. But actually he is a Damocles sword really hanging over his head under the Equal Status Act, and eventually I've no doubt a case will be taken against him under the Equal Status Act. A further example occurred this week in respect to denominational schools. Now, the vast majority of schools in Ireland are denominational run, and because Ireland has been historically an overwhelmingly Catholic country, the great majority of them are Catholic. This week, a government ordered report was published that said about these schools, in order to make denominational schools, not state schools, no, denominational schools, more inclusive, they must do the following. They must change their enrolment policy to a first come, first served enrolment policy, so that, for example, the Church of Ireland school cannot, in cases where they're full, admit Church of Ireland children first. So they must change their enrolment policy. They must also change the way religion is taught, so that in addition to denominational education, which now must only be taught at discrete times of day, they must teach all the world's religions. This report also seeks to place conditions on the display of religious symbols in denominational schools. Remember, not state schools, denominational schools. that the cross, for example, cannot be displayed on its own, that the religious symbols of every child in the school must also be displayed alongside the cross, for example. If you're celebrating a Christian festival like Easter or Christmas, it would appear that you must also celebrate the festivals of every other child who's in the school, whatever their religion may be. Remember, this is in Christian schools. And finally, prayers must not violate the human rights of the children in the schools. It's not at all clear exactly what this means, but one interpretation is that the Hail Mary, for example, might be deemed to be sufficiently all-inclusive because it's a Catholic prayer, or indeed the Our Father, being a Christian prayer, generically Christian prayer, might also be deemed to be sufficiently all-inclusive. So therefore we have to state now, this is not official policy yet, it's simply a list of recommendations, the state telling denominational schools that we will take control of your enrollment policy, we will tell you how you must teach religion, we will set conditions on how prayers are said in your schools, and we will set conditions on how you celebrate your festivals and how you display your religious symbols and art. So these are simply some of the things happening. Ireland is trying its utmost in terms of official policy to repudiate to the greatest extent possible this Catholic past. And these are simply some examples of that. Thank you.
All right, thank you very much.
Now what I propose to do is to ask for a series of comments from the floor and not go back to our participants for a little bit, so we'll have a lot. Otherwise we'll just have a debate between us at the top here. So I want to hear what you're saying. So first, you're of course from Northern Ireland, aren't you?
Yeah,
yes.
I was going to say I'm taking advantage of the fact
Yes.
I'm from Northern Ireland. I was born in Dublin, so
Yeah.
I can play one off against the other as
Yeah.
it is appropriate. I'd like to come back to something that Stephen said, but which also ran through the other papers, and I think will run right through today. And that is the analogy that gay is the new black. Stephen said, gone are the days when hotel owners could put up signs saying no blacks. Now, I was born in Dublin. I'm old enough to remember coming on holiday to England as a little Irish boy and seeing those signs in the windows. No coloureds, no Irish. And my daddy had to explain to me why it didn't really apply to us. But I want to argue that that is a category error to equate, as it were, gay and black. The analogy is flawed on two grounds. Let's take the bed and breakfast owner.
Could you keep your remarks pretty brief, please?
Yes, I have a short version and a long version.
Well, you must have
I'll
a
do
very
the
short
short version. The bed and breakfast owner who in old days, 60 years ago, would have refused a black man a night's accommodation. The Bulls will not, as I understand it, refuse a gay man a night's accommodation. And you want to think through the logic of that. And the logic, I think, has come down to the difference between the ontological, which is black, and the behavioural, which is gay. Now, my second point is that the skin colour analogy is based on genetics versus non-genetics. And homosexuality is genetically not determined, whereas skin colour is genetically determined. Now, it's at that point I could amplify and go into the science, but certainly.
Yeah, well, thank you very much. Right, now...
Let's open it to the rest of the floor. Could I just ask you to do two things, to say who you are and where you come from, and also to if possible, ask a brief question or make a brief comment. Yes, first.
Linda McLean from Boston University. I would just be curious about Professor Finnis and Professor Laws, different, well, I'm very different reasons, but here's the following question. Professor Laws sort of paints a picture that the majority of British people aren't all that agitated about equality rights for for homosexuals, and in fact support it. And Professor Finnis has said, I assume referring to something in my paper, that it's deeply demeaning to married couples to be told somehow that their marriage is the same as the marriage of a gay couple. So I see a little bit of a gulf between your two positions on kind of the impact of same-sex marriage on heterosexuals and sort of public opinion about it.
Good. Yes.
Rick Garnett from Notre Dame. This is for Professor Law. At one point in your discussion, you said that whether or not an accommodation or an exemption for religion would be appropriate might depend on whether the religious belief in question was deeply felt and on whether the person could give a coherent account of that belief, and presumably that belief's placed within a larger structure. And my reaction, for what it's worth, it's not really a question, is supposed to be sort of surprised by that and to wonder why it should matter, or whether it should matter that much, whether a particular religious believer, I mean, we are only human after all, and most of us aren't theologically trained, can really give a coherent account of every aspect of a religious tradition and a kind of integrated web of religious practices. And I think it's also a reality that for most religious believers, again, this side of heaven, we don't always feel as deeply as we ought those religious injunctions that we nonetheless should comply with. So I guess I'm a little hesitant to have religious exemption depend on whether a particular believer is able to give a theologically rich account of the obligation in question.
Right, yes.
Chris Sugden, Oxford Center for Religion and Public Life. Two observations and questions, please. Number one, could you please comment a little bit more about the internal discussion on the human rights, the identification of human rights? Because we are discussing by and large at the moment within the framework that human rights are some sort of commodity that people have and trade, that it's within property rights, and therefore you're infringing my property rights if you do not allow me to do X, Y, Z. Joan O'Donovan in Edinburgh has written extensively engaging with that and saying that that is to divorce, that is a very recent notion, it is to divorce human rights from the Christian notion of sort of the common good and common order. And secondly, if I could ask if we could link the discussion particularly with the issue of the common good, with religious rights or religious freedom on its own seems to restrict it to an equivalent of Mormons refusing to have blood transfusions, which is refused on the basis of the common good and the suffering of people who would be disadvantaged. I draw your attention to a report in the Times 2 days ago where gay men have surrogate babies that are composed of mixing their genetic material with the eggs of Ukrainian women, which are then carried by poor Indian women in Delhi, who lose their social status, their community position, their conscience and their values. Whose justice are we talking about in this sort of situation? It seems to me that there's a whole area of the common good which is neglected at the price of other people's common good that is just completely not in the discussion at all. Would you comment on this, please?
Right, other comments or questions? Have you got any?
Right.
Yeah, just one over here first, yes?
Robin Wilson, Washington
Yes.
and Lee. I just want to follow on this gentleman's remark and ask not only what the discussion of the common good is, but we basically, at least in the United States, wholesale withdrawn from the idea that the state has a say or an interest in assisted conception, whether it's by homosexual couples or heterosexual couples, whether it's by single parents who intend to create children that will have no connection to a father or mother in their life. So I think part of this dialogue is really about the state's withdrawal entirely from a sphere that I think it has some interest in, and if it does have an interest, what is that interest?
Good. Was there one over here? Yes.
Hi, Elizabeth Hunter from the think tank Theos. I find it very helpful if the panel would comment on this issue around requirements and manifestation in Article 9. A lot of the public discourse around this issue in the British mind particularly has been about what is and isn't a requirement of faith, and that obviously and that obviously is a very complex thing within different faiths themselves, and I wondered kind of within the spirit of that article whether there was any attempt to define those terms, or whether that's just being left into individual cases, and how you think that might proceed better.
Well, let's get some comments now. Could I start from this end this time? So, John, could you pick out anything that has been asked that you particularly want to comment on?
Well, just on the last thing, I mean, it's a very ad hoc sort of category in the jurisprudence. It's used with a good deal of ad hocery by the tribunals that deal with it in relation to claims by Christians. The courts are inclined to say, well, this is not a requirement of the Christian faith. In the case of claims by Muslims or Sikhs, the courts are much readier to find that it is a requirement, such as to wear a certain sort of headscarf, which may or may not in fact be a requirement of Islam. So I don't think there's any deep learning to be had here. It's all very loose and ad hoc, if not ad hominem. As to the other matters, well, I think the issue of the common good is of central importance. The idea of human rights is in no sense an invention of the 20th century. It's not, I think, in the least to be attributed to Maritain or French personalism. Maritain was a good Thomist, and the roots of human rights thought go back to Aquinas and far beyond him to Aristotle. And people can write decent books and have about human rights in Aristotle. The lingo, the jargon of human rights has a certain sort of novelty, but the conception of justice as giving each person his or her due, her entitlement, that is, his or her right, as Aquinas very clearly articulates, as the Roman lawyers already articulated not just the Christian Roman lawyers of the 6th century AD, but even the pagan Roman lawyers of the 2nd century AD very clearly articulated the idea of a right that pertains to each person, and which slavery, the institution of slavery, contradicts. In many cases, those lawyers were not about to do anything about the contradiction between the law of slavery and the rights of human persons, but they clearly put it in their law books that there is a contradiction between the rights. So the 20th century didn't invent rights. And if we think about it as an issue of justice, that we realize that we can't just look at one end of the two-party relationship. At one end is someone with a right, the other end is someone with a duty. There is no right without the duty, and in truth there is no duty without the right. Both are vital concepts, but to say that you have a duty to this person is something that can only be justified in terms of a whole conception of what we call the common good, that is to say, of human flourishing as individuals, as families, as neighborhoods, as states, and as members of the human family. Without a reference to that all-embracing conception of human well-being, you have no justification for asserting a duty, and therefore you have no justification for asserting a right.
Good. Well, thank you very much. You got any comments?
Three. Yeah. Picking up John's point about I obviously didn't make myself clear. I didn't say that Maritain invented human rights. I said that his role was crucial in enabling a bridge to be built between the notion of human rights that was emerging at the international level and then current Catholic debates, which enabled a degree of consensus to emerge over the language that was used in the Universal Declaration. It would be obviously ridiculous to say that Maritain, or indeed human rights, were invented in the 20th century, and I didn't say that. But I certainly emphasize the importance of that moment historically as important. Second point in terms of the manifestation issue that you raised. I agree with John in terms of I don't think it's a particularly fruitful area for further analysis. But I think there's a larger question in play here, which is the issue about Article 9.1 more generally, and about the current court's approach to that. And it seems to me the more critical question is actually the notion of interference. And it's that that gives rise to most of the problems in terms of it being applied. That is, particularly the notion of interference that says that there is not an interference if you are able to practice your religion, even though you may, for example, lose your job by practicing your religion. Yeah? In other words, it's an attempt to distinguish elements within the religious person's identity, if you want to put it that way, that says you can do what you want, but the state can also discipline you in any way that it wants as a result of that, and they are nevertheless free to act as a religious person. There is a parallel here, which I suspect many in the audience will not like. There is a parallel here about the question that's been raised about the act status distinction with regard to homosexuality. That is that there is as John rightly pointed out, a strong argument within human rights cases that rejects the distinction between status and act. That is essentially the argument that is being made in terms of rejecting the approach that the Court of Human Rights is taking in Article 9 with regard to the notion of interference. Very similar argument. But you can't have it both ways. That is, if you aren't one to argue that religious persons should not be, as it were, divided up in terms of their beliefs and their actions, then a very similar argument has to be addressed in the context of homosexuality. That's my second point. Third point, if I may, is to come back to, is it Mr. Sugden, who raised the question about how one characterizes, as it were, human rights, I think was the issue. And in particular, how far they should be regarded as a commodity, or as Joan O'Donovan addresses them as property rights. Yeah? And there was a very interesting discussion at Blackfriars a few months ago on just that issue. There's one word that I think that I've mentioned that I note has not been picked up in this discussion about the nature of the rights in play here. There's been a lot of discussion about the common good, but there has been no discussion about the notion of dignity. And dignity is crucial to this discussion in a way which, if we do not focus on it, will mislead and not enable a genuine debate and discussion to take place of the type that you are advocating. Right. So if you want a dialogue on this stuff, rather than simply didactic, you will do what I tell you, if you want a dialogue on it, you will engage in the notion that, for the moment at least, both communities share of the notion of dignity. That is, that it is central to the question of human rights understandings, increasingly central. And it is a bridge that potentially allows a dialogue to take place. In a way that notions of the common good do not, because the notions of the common good have been regarded, rightly or wrongly, as sort of captured by a particular understanding. Right? So common good does not resonate in terms of debates within human rights. Dignity does. That was Maritain contribution, in part. So my point here is, if you want to have an understanding of the notion of human rights as understood in the human rights context, then you need to understand it not as a property right, but as essentially underpinned by a notion of dignity. And that is a common understanding that I'm suggesting, a common understanding between religious understandings of right and human rights understandings of right. Neither of them, I think, have an understanding, and here I just disagree with Jonathan Finn, neither of them have a current understanding of it as property rights. That's not the way it's understood. It's not the way it's understood in human rights law. It's not the way it's understood in human rights discourse more generally. So I'm suggesting that if you want to take it seriously, then you engage with it as a question of dignity, because that enables the dialogue to take place.
Good. Well, thank you very much. Well, coffee's calling, but we must give Stephen the last word.
Right. Okay. Well, I just wanted to take the opportunity, just to begin with, to say that I was very sympathetic with Bishop Tartaglia's concern that he might be arrested, perhaps within the next couple of years, and prosecuted for expressing his views on homosexuality and so on. But I don't think that's very likely to happen. In fact, one of the cases that you mentioned yesterday involved a man, I think his name was Smith, Adrian Smith, who was demoted and lost a lot of pay because he had expressed a view about homosexuality online. Now, I mean, are you aware that one of the leading campaigners for Smith is Britain's leading gay rights activist, Peter Tatchell? Right. Peter Tatchell is fully aware that this was a terrible thing that happened to Adrian Smith, and he said, in a democratic society, Adrian Smith and others have a right to express their point of view, even if some people think it is misguided and wrong. Freedom of speech should only be penalised in extreme circumstances, such as when a person incites violence against others. Smith's words did not cross this threshold. So, now that's my view too. Smith did nothing wrong. Of course his freedom to express himself in that way should be guaranteed. He should not have been demoted. I sign up to secularism in the sense that I think that we should have a society in which there's a level playing field so far as religious and non-religious belief is concerned. We shouldn't penalise religious belief, but neither should we privilege religious belief. We should be even-handed. We should protect the freedoms of the religious people to say what they want and the non-religious people to say what they want. I agree that there have been cases where people have been treated unfairly and their religious freedom has been unjustly curtailed. But they're quite unusual. And I think that is one of them. I think when you look at other cases, it is not nearly so clear that we are dealing with a genuine, unjust limitation of religious freedom. So we need to look at these cases case by case. If we're going to make exceptions or exemptions or whatever you want to call them, we need criteria which we can apply, which are clear and just, and we all understand what those criteria are. And I made some suggestions. The gentleman over here suggested that perhaps one of the criteria that I suggested might be too strong, and maybe it is. We can argue about precisely what criteria should be applied. It's going to be a hard job figuring out what they are. But the one concern that I have is with the idea that having religious beliefs, well, that's special. The religious beliefs are the ones that should really be specially protected. I don't see any good reason for that. I can't see any adequate justification for giving that special protection to only religious beliefs. In fact, Tom Farr in his opening remarks yesterday said that religious and non-religious beliefs should have the same status. Exactly, they should have the same status. So when a woman, a BA employee, has a little necklace with a crucifix on it, okay, should BA have a jewellery policy which says no jewellery, blanket ban, or should the law step in and protect her right to have the little crucifix because it's a crucifix and not a political symbol, say? I'm not sure that the law should step in. I think that the BA probably should just have let her wear the symbol. I think it was a rather trivial case. But I'm not sure that the law should be stepping in and saying, no, because it's a religious symbol, well, that deserves special protection. Whereas if it had been a British Humanist Association symbol, well, no, she can't wear that. You know, BA within their rights to rule that out. So whenever you consider these individual cases, ask yourself, are we privileging religious belief? And you'll find that in very many cases you are, though you didn't realise it. It's just habitual in certain religious circles. You don't even realise that you're doing it because it seems so obvious that that's just the way things should be. Just take a step back and think about it. Are you privileging religious belief? And if you are, then you either have to come up with some good reason for doing so, or you should stop doing it. And that is the position of many Christians, such as the people from Ecclesia that I quoted earlier. So that's my position. I just want an even, level playing field. I agree with what John Finnis said at the beginning, and I disagree, with you. I disagree when John Finnis apparently suggested that religious beliefs have a, quote, special weightiness. What does that mean? Because that seems to contradict what was said at the beginning of the conference, that actually, no, they have the same status, they should have the same status as non-religious beliefs. So which is it then, right? Argue if you like that they should have a special status, but you'll need to provide some justification. So and I know I haven't answered any of the questions, but I feel...
But coffee's calling.
It is calling, and I'll talk to you afterwards. I wanted to talk to you, because you made the one particularly interesting point about the analogy I drew, which...
Can I ask you to just deal with that
Yes,
personally?
shut up.
Because we must stop for coffee, because we are already behind time.